Many disability claimants, including my clients, are frankly terrified about appearing at a disability hearing. Hearings are now virtual by telephone or video, so I think a lot of the fear has gone out of it, but it's still a little bit concerning when you've never been through this before. You need to know what to expect. And I go through with my clients a fairly lengthy pre-hearing process, but I want to explain to you big picture what happens so some of that fear you may have will dissipate. I'm Jonathan Ginsberg. I'm a Social Security disability attorney. I've been doing this for about 30 years. I represent clients in all 50 states because, again, hearings are virtual. So I just want to walk you through a typical hearing, and this really applies to both video and telephone. They're pretty much the same. The only difference is with a video, you use Microsoft Teams, and the video part is on. You can see the judge can see you, and you can see your attorney. Some people like the connection there when you have the visual, although again, I find that telephone hearings typically work a little bit better because there's less to go wrong technically. So let's just walk through what's going to happen at a typical hearing. So let's say you have a hearing scheduled for 11 o'clock in the morning on a Wednesday. So literally right at 11 o'clock, most of the time, sometimes I run late, but usually right on time, you're going to get a phone call from the hearing office. And you've received a notice already, which tells you the name of the judge and the hearing office that's associated with it, and of course the time and date of the hearing. And the hearing reporter, someone who operates recording equipment, will get you on the phone. They'll typically have me or your attorney on the phone already. And then they'll have a vocational witness on the call. Vocational witness is there to help the judge understand what you did in the past, the type of work you did, and to answer hypothetical questions about what you might be able to do given certain limitations that the judge finds. The vocational witness is not there to hurt you or help you, but is there to help the judge understand the vocational implications of your medical issues. Remember, Social Security disability is about not just your medical problems, but how your medical problems prevent you from working. So having a vocational witness there helps the judge translate, if you will, your medical issue into work limitations and how severe they are, and are they work preclusive? That's a decision for the judge, but the vocational witness will answer questions for the judge. I'll talk about that in a second. So hearing starts, everybody's on the phone. Again, it's 4 people and the hearing reporter, the vocational witness, the judge, you, your attorney. Every once in a while, a judge will have a medical expert, but that's pretty uncommon. So usually it's 4 people plus the hearing reporter. The hearing reporter is there to operate recording equipment, make sure there's a good recording. They will ask you not to use a speakerphone. They will ask you to be in a quiet location in your home. If they can't hear you, they may tell you to if you've got earphones, to take them off and actually hold the phone by you, by your ear. The hearing reporter is there to make sure there's a clean recording. They use Microsoft Teams for this. And by the way, you're not allowed to make your own separate recording, but we can get the official recording usually the next day. I can download it and send it to my client. So that's what the hearing reporter is there to do. Also, the hearing reporter will tell you, please say yes or no, not uh-huh or mm-hmm. Make sure you speak up. And really important, never speak over the judge. Judges sometimes will ask a question, and they may start to, you may feel like you want to answer the question before it's been fully asked. Let the judge finish. Wait a second, and then answer the question. You never want to speak over the judge. That's inconsiderate, and you don't want the judge to find that you're not a polite person. That will work against you. So you definitely want to let the judge finish. My rule of thumb is when the judge talks, everybody else stops talking. That's just a simple way to do it. Even if you're not finished, you can always come back and finish it later. And of course, with an attorney there, if the judge cut you off, you didn't get a chance to finish what you had to say, then I'll be able to ask the question again and give you all the time you need to answer the question. So we're in the hearing. The judge has got everybody there. The judge will introduce himself or herself, then ask you some identification questions. Please state your full name, your Social Security number or the last 4 digits, your mailing address, as well as your phone number. They want to make sure they can get a hold of you. The judge will ask you to confirm you're by yourself in a private location in your home. The judge will ask you to confirm you're not making a separate recording in the hearing. He or she will ask me the same thing. And same thing of the vocational witness. The judge will then ask me if I reviewed the record. I have. Any objections to the exhibits? No objections. He'll ask you and me, Do we consent to a telephone or video hearing? Yes, no objections to that. The judge will ask me, have I reviewed the issues with my client? Yep, the issues are going to be work capacity and the medical issues that prevent a person from being a reliable employee. The judge will ask me, will I waive a formal reading of the issues, which basically saves a little bit of time. And then the judge will swear you in, and he'll say, or she will say, raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Yes. The vocational witness, yes. The judge will ask me, do I want to give an opening statement? I will in some cases. Other times, if I've written a brief, I'll say, well, Your Honor, the brief is Exhibit 20E. I'm happy to restate it, but if you have a chance to read it, I won't waste your time on that. Usually the judges have read my brief. They've got a pretty good idea what I'm trying to argue. The judge will start out by asking you about your past work. And we've prepared for that. They're going to go over your work in the last 5 years. The judge will want to know your job title, what you did, how much you had to lift, carry, all the different physical elements of it. Were you supervising people? Were you climbing ladders? Were you bending, kneeling, crouching, stooping, that type of thing? And we'll be prepared for all that for your past jobs over the last 5 years. The judge will then ask you, sometimes the judge will say, all right, Mr. So-and-so or Ms. So-and-so, tell me in your own words why you feel you're not able to work. I call that an elevator speech. You want to be able to give a very brief explanation of why you'd have trouble working. We've prepared that. You'll have it in front of you. And then the judge will typically turn it over to me. Or the judge may ask you more questions about your medical issues. But when they turn it over to me, I'll typically start out with the most significant medical problem, ask you about it. I see in the record that you've had some back problems for the last 7 or 8 years. When did it start? And you can kind of talk about how you were in a car accident or you fell off a ladder or something like that. And I'm very conscious at the time, so I'm not going to spend a lot of time on things that happened while you were still working. I'll kind of fast forward it to the time when you stopped work. What made you stop working? We'll go over all the symptoms. I'll ask you questions about specific activities: sitting, standing, walking, lifting, carrying, kneeling, crouching, crawling, stooping, climbing, things like that. We'll talk about, do you need to rest during the day? And if so, for how long? We'll talk about medication side effects. We'll talk about episodes of pain, what triggers the pain, how bad is it, what you do when you have really, really severe pain, how you've tried to work through it, kind of go through the medical history. If you've had surgery, was it successful? Just really go through the medical record in a fairly abbreviated form with the idea of painting a picture that you have been cooperative with your doctor. You've done everything the doctor's asked you to do. But despite all this, you have medical issues that create symptoms or medication side effects that would be work preclusive. Medication side effects might be nausea. It could be difficulty of focus and concentration with our narcotic pain medication. It could be having to use the restroom every 30 minutes with something like Lasix, a diuretic. We'll go through all that. We'll go through all the medical conditions, all the issues that I think are most relevant. Then after testimony, which is about 20 minutes, 25 minutes of you talking, and me asking questions. And by the way, if you kind of get off track and you start rambling on about something that was 30 years ago, you fell off a tractor when you were 15 years old, but then you were able to work for 40 years after that, I'm going to stop you. I'll cut you off. And I even tell my clients ahead of time, I'll be rude to you. If you start rambling, talking about something that's not relevant, I will cut you off. You need to be aware that I'm going to do that, not because I'm trying to be rude to you, but because I want to focus on the things that are most important for your hearing. After taking testimony, the judge will ask the vocational witness to classify your job using a resource called the Dictionary of Occupational Titles. You can look at it at occupationalinfo.org. Horribly outdated, last updated in the 1990s. They still use it for some reason, but it'll classify the job using a numerical code like 563.467-10010. This is a light, semi-skilled job with an SVP of 4. SVP stands for Specific Vocational Preparation. So basically it tells us, is it a sit-down job, a light job, medium job? Is it semi-skilled, unskilled, skilled? And all these things have meanings. And I'm not going to spend the time here, but all those terms have meanings that are relevant to Social Security. The judge will then ask about transferable skills, things you may have learned at the job that could be useful in another type of job. Then the judge will ask a series of hypothetical questions. Mr. Vocational Witness, I want you to assume a hypothetical individual, the same age, work experience as the claimant, same education. This individual is limited to the light exertional capacity, which is defined as standing and walking 6 out of 8 hours in the day, sitting up to 2 hours in a day, lifting 10 pounds frequently, 20 pounds on occasion. That's the definition of light work. However, this individual has further limitations, no climbing ladders, ropes, and scaffolds, no working around hazardous equipment or moving machinery. This individual needs to avoid extremes of temperature or pulmonary irritants. Based on that, could this person return to past work? Probably yes. A lot of times the first question is pretty mild. And then they'll start adding to it. This individual cannot operate foot controls with either foot, cannot reach overhead with the right dominant arm over shoulder level because of shoulder arthritis, severe shoulder arthritis, and reverse shoulder replacement. Would that change your answer? Maybe it would eliminate certain jobs. Maybe there are other jobs you could do. Then the judge will keep going. This individual, because of chronic pain medication side effects, would be off task for 15% of the workday, or would likely miss 2 or more days of work per month. Would that be consistent with competitive work? I'll tell you the answer there is no. We want the judge to arrive at a hypothetical question where the answer is there are no jobs I can identify. The vocational witness is looking at this resource that has thousands of jobs in it. Again, some of them no longer exist, but still some of them are still there. There are a lot of unskilled, sedentary, and light jobs that a person with some mild to moderate problems could do. We want to convince the judge during the hearing that your problems are not mild to moderate. They are moderate to severe, where the combined effect of a lot of moderate to severe impairments would leave you without the capacity for work. At the end of the day, we want the vocational witness to say, Your Honor, there are no jobs I can identify. I'll have a chance to cross-examine the vocational witness, which, depending on the circumstances, I would do either somewhat mildly or aggressively. And then the judge will say, thank you very much, Mr. and Ms. So-and-so. I'll get a decision out in 4 to 6 weeks. I wish you the best, and we all hang up. Then, of course, I call my client right there afterwards, and we go over what happened. That's what happens. It's really 45 minutes. You'll be talking about 25, 30 of those minutes, answering questions, talking about your case. The key here, I will tell you, preparation. You should not go into a disability hearing not knowing the questions are going to be asked of you. When you're my client, you will know the questions because I give you a printout of the questions you're likely to have. We go over it in a pre-hearing call that may take hour and a half, longer than the hearing. We practice getting your answers where they make sense. I've had many times people with legitimate claims, and I'll say, well, how much can you lift? Oh, about 50 pounds. I'm like, really? 50 pounds? You know how much 50 pounds is? And we talk about, we give an example. Okay, could you lift, 2 25-pound, sacks of potatoes or something like that? Well, no. People sometimes overestimate or underestimate their capacity. And so we practice and we go through it to really give you a clear idea of what your capacity is. I always tell people, the judge says, what do you do during the day? Or what is your day like in terms of how much you can lift or carry or whatever? Don't say every day is a little different. It depends. You want to pick a day. And I always tell people, not your best, not your worst, but think about kind of in the middle minus. So if it's a 1 to 10, 1 is just absolutely you're in bed all day, 10, you're feeling 100%, pick a 4, a day that's a 4, and describe what you do on that day of that 4 day. So it's not your worst day, but it's not the best day either. It's a little bit below average. That's a pretty good way to look at it. But you want to be able to describe your activities, your functioning, your capacity during those days. The nice thing about telephone hearings, you can have it written down in front of you. Not that you want to read anything, but you can certainly, that way if you get nervous and you don't remember how much you said you could lift, it's right in front of you. And again, it's on my printout, so I'll give it to you so you can see what you answered so that you answered the same way. And if you just answer truthfully, come across and present yourself as a reluctant claimant, you don't want to be here, but you have to, that you go back to work if you could, you're being fully cooperative with the doctor, you're trying everything you can to, you're losing weight, you stop smoking, all these things, that can go a long way to taking a case that's kind of on the edge and pushing it into the win column. So that's what happens at a hearing. Again, obviously a lot more about your specific case, but I wanted you to know this kind of big picture, what to expect in the 45-minute hearing. Obviously, you've waited 2 years for it most of the time, and you want to make the most of every minute. And like I said, I do a brief so that we don't waste time with things that can be written down. I even anticipate your testimony a lot of times because we've already talked. But you have a chance to put the face to the name and present yourself as a believable, credible, honorable person who's only asking for disability because you have no other choice. Hope you found this useful. Visit me online at ssdanswers.com. You can ask for a case evaluation. You can download my Secrets to Winning Disability Survival Kit. It's delivered by email. You can join me on Wednesday evenings at around 8:30. I do a live stream where I answer questions from clients and non-clients, people that just tune in. Actually, some of my clients show, but not all of them. A lot of people just have become kind of regulars. They ask questions about the disability process, how to apply, what it takes to win, my opinion about certain impairments, my experience with these type of things, what happens if you have a continuing disability review, what's going on in the news, is there any significant changes, any interesting cases, are there going to be legislative changes? We talk about it all. And again, people just ask me questions, I answer them. I'll have guests sometimes, other attorneys, Social Security employees, present and past, medical doctors. So it's actually a lot of fun. I think it's very useful. And I put the recorded live streams on the YouTube channel if you wanted to check one out to see what's involved. But stop by for 45 minutes or an hour. You may find it's very, very useful, and bring a good question. Happy to try to answer it for you. So that's all I have for you today. I appreciate you tuning in and listening to this video, watching this video. And if I can be of help to you, please do let me know. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.